All right, we are recording.
Okay, so this is a meeting of the Land Use Review Board as we have all 5 board members present, it looks like. Hi, everybody. Primarily, the purpose of the meeting is to discuss our appeals report and specifically municipal permit appeals. So I'm going to open the meeting, but then turn it over to Brooke Dingledine to progress through the specific agenda for today's meeting. But I'm Janet Hurley, the board chair, and let's have board members introduce themselves as I see them. Sarah.
Sarah Hudd, board member present.
Kirsten.
Kirsten Sultan, board member present.
Alex.
Hi, everyone. Alex Weinhagen, board member.
And Brooke.
Brooke Dingledine, board member present.
Thank you. And so, Brooke, can I turn it over to you?
Thank you very much. Welcome everyone to meeting number 6 of our stakeholder group for appeals. I'm going to start out just by briefly going over our agenda for today. Let me share my screen. Oops. Let me try that again. So what we wanted to focus on for today's meeting is on the assumption that municipal appeals would come to a board as opposed to remaining with the environmental division. We wanted to look more closely into building an actual model to find the most viable option for the board to consider. As I mentioned earlier, there are issues of capacity, timing, given all of the tasks that Act 181 has in store for us. And that is a heavy lift. We have a lot of studies going on, reporting to do, rulemaking as well to catch up on, housekeeping, that kind of thing. But we are also analyzing that level of capacity for at least the current staff. And what we're trying to determine today is talk about the types of cases. There are 2 kinds of appeals to the environmental division regarding municipal cases. One are the permitting matters, and then there are enforcement cases as well. In terms of direction from the board, there was general agreement that enforcement cases should remain with the court. We also discussed that with regard to Act 250 enforcement, where basically the Land Use Review Board acts as the prosecutor, if you will, to give you an analogy. And the board felt it was appropriate to keep that enforcement authority with the courts. So that was one of our first conversations in terms of one of our key issues is we wanted to discuss permitting versus enforcement, feedback from stakeholders about that line of demarcation. The other matters that we wanted to focus on are the standard of review. And there seemed to be a lot of arguments against altering de novo to on the record at the municipal level. And I think that our board is very cognizant of that concern. And in terms of some of the discussions the board has had, we have been contemplating, at least for the Act 250 appeal, some sort of hybrid on the record plus some opportunity to supplement the record. So we'd like to discuss that in the context of municipal appeals. And most importantly, we want to talk about the board structure and composition. And what I want to do in order to start off the conversation is just to remind us about the volume of cases. And also I'd like to show you from our original environmental board rules, I think it's a 2004 version, the last version that existed. In Rule 41, there is there was a rule that provided for hearing officers and panels of the Environmental Board, which are two of the statutory issues that were raised in our charge for this appeals study. So to look back at a rule that we had that actually operated in that manner, I thought would be helpful and informative for this conversation. So with that, I'm going to switch screens, hopefully, and just want to, first of all, thank profusely the Environmental Division for helping us to sort out cases and what types of appeals that they are. Let me see if I can make this a little bit bigger. So what we were talking about in terms of municipal de novo appeals, which is the majority of the cases in Vermont, most of the municipalities are not on the record. There were 61 in fiscal year 22. There were 62 in fiscal year 23 and 47 in 2024. And then we were able to get a breakdown of the housing appeals within each of those categories. And it basically is approximately a third of the cases. It varies a little bit year to year, obviously. The other issue or the other type of appeal is the municipal on the record appeals, which are the larger municipalities typically that package up the record and send it to the court, and then it's not new evidence. It's not a de novo review. And so in 22, there were 6 of those, 2 were housing related. In 23, there were only 5, 1 was housing related, and then on the record in last year was 12, half of them being housing appeals. I would note, and I will provide this to everyone as a copy, but the court notated for us, just in terms of their classifications, they were erring on the side of being conservative, incorporating something as a housing appeal. A couple of examples that were noted for review were just the fact that some of them were short-term rental. One was a year, they were not traditional housing cases, but because they related to housing, the court appropriately noted that and incorporated them in the count. So this is the volume of cases that we're talking about if we were only focusing on permitting, not enforcement. And then the other thing that I just wanted to briefly go over with folks is these are from the original Environmental Board rules. And Rule 41 provided for administrating hearing officers or panels. And what it enabled the board or the chair to do is to appoint a hearing officer or a subcommittee of the board, which would be called a hearing panel. And those folks would be able to appeal or petition for party status before the board. And this rule set out how the appeal would occur. It gave an option or an opportunity if the case was considered complex by the parties and it had been assigned to a hearing officer or a panel, that could be questioned with the argument that it was a complex case that should be heard before the board. And then the board would have to decide whether or not the entire board would sit on that case. There was also a provision for if the hearing officer believed that it was a complex case that should be heard before the full board. That was also an option. So that's in B. There was a reasonable opportunity to object. The full board would make a decision, and that was a final decision. It appears that it was unappealable. There was a provision that the normal environmental board rules applied, whether it's before a hearing officer or a panel. And then in D, it provided for the hearing officer or panel to prepare and transmit to the board and all parties of record recommended findings of fact, conclusions of law. This part of the rule provided, so this is similar to the PUC, the Public Utility Commission, where they have a hearing officer who makes a decision that's a recommendation to the board, and the board accepts, rejects, or alters the decision. But after an opportunity for briefing and oral argument, and you can even ask for a site visit of the PUC, it mirrors that process. So those same APA findings and conclusions of law are required, of course. And that oral argument, it is another step in a sense. It's a recommended decision, and then there was a full board decision of that hearing officer or panel decision. And then the other interesting thing was there was a time limit for 20 days for the decision to issue after completion of deliberations by the board. So a little bit different than, for example, in zoning, where you have the close of the evidence as the beginning of the time period for decision making. Now, I realize this is within the Act 250 context, obviously, but I wanted to be able to show you that this is not an unprecedented notion of setting up hearing officers. We talked about that model or the similar model at the Public Utility Commission. So I just wanted to let people know that we already have old environmental board rules that in many ways are very useful in building the ultimate rules of any proposed viable board model that our board decides to recommend or adopt. So thank you for listening to all of that information, and I would love to open up the floor. This is our opportunity for our stakeholders to have the board hear directly what your feelings are, your opinions, and I'm going to start right off with Liam. I see you as number one. Please, Liam. Oh, and could you introduce yourself, since well, all of our board members have been to at least one of our stakeholder meetings. Very helpful if you could just introduce yourself and tell us who you are in terms of your stakeholder status.
So,
Liam?
good afternoon, Liam Murphy. I'm an attorney with MSK Attorneys in Burlington. I've been practicing land use law for more than 40 years here in Vermont. I represent owners of property, opponents to development, developers, municipalities. I've practiced before the old Act 250 board as well as the environmental court. I first apologize that I was unable to come to the last two meetings, and so I may be behind in my understanding, but has there been a decision that the board will consider or will take jurisdiction over municipal appeals? Or because this sounds like we're talking about the process to do that, not whether it's a good idea.
Yeah, Liam, let me respond to that. So we're trying to focus on creating a board model. What is the best option for this? What kind of resources, structure, credentials, what have you, to create something to choose from. There's absolutely no decision. We don't have enough information at this point to make any recommendations, but I felt it was very important. And so we're trying to put aside the debate between whether court or board, which, that tug of war, that debate. We're trying to right now create the best board model we can come up with to consider to figure out whether that's viable, makes sense, and would the board recommend that. And so we heard a lot last time about, Act 250 not coming from the court or not coming from the court. And what I'm trying to really focus on is trying to create that model today. And it's not to shut anybody down, because I fully intend on having another meeting specifically about the court and that debate. But we
Okay.
need to get a little bit farther with more of a fully baked loaf of bread to figure out what it is that we're comparing.
Well, I appreciate that. Let me just take a few moments to comment on the concept, because I do think it'll help inform the structure.
Yes, and Liam,
There
please
is-
do. Please do.
Yeah,
We
there-
did have a lot
there-
done,
there-
and we didn't have you
Right.
last time. So by all
Right.
means, please share.
There is a massive difference between how Act 250 and municipal land use reviews work. Act 250 is a set of criteria that focuses on impacts of properties, of projects on various resources that are designated. The rules are statewide and apply to each and every project. And over time, there has been development of a common law of those, an interpretation of Act 250. Act 250 does not prescribe any use. It doesn't prescribe any size, any location of a property. So the commissions and the board focus on a series of impacts of properties that can be projects that can be applied across the state. Zoning or municipal land use is exactly the opposite, or very different from what Act 250 does. It is prescriptive. It says you shall have this size of property, you shall have these setbacks, you shall have these heights, you shall have these setbacks. You'll have a list of uses, permitted, conditional, some requiring site plan, others requiring subdivisions and PUDs and PRDs. It's a very, very different focus. It's a focus on prescriptive uses that are imposed by each town. So you have 200, maybe I don't exactly know how many zoning ordinances there are, but maybe I think it's over 150, maybe up to 200 different individual ordinances throughout the state that apply each one of those prescriptive criteria very differently than the other towns and cities. There's not one set of rules. Towns are given broad authority to adopt. So I think the concept of the board with either the board or a hearing officer or a panel hearing these very disparate type of uses, that uses and prescriptions under municipal regulations would be very difficult and would impose a requirement for a massive amount of support with a court. And especially now recently, most recent Supreme Court decision was a decision that allowed the environmental court to consider any inherent real property rights of the parties that are necessary to decide a decision. In that case, a question about whether somebody had a legal easement. The court said it did. The environmental court initially said it didn't have jurisdiction. The Supreme Court said that was inherent in making a decision about a permit. So now we're not only talking about these wide range of prescriptive structural and use issues, but we're also talking about a whole series of potentially legal claims. And I just don't think that the board or a portion of the board in a panel or an individual hearing officer is the place to do this. And if the board were to take this jurisdiction, I think it would need a massive infusion of resources in order to be able to hear these 60 very disparate cases. And so anyway, that's my thought.
Great, thank you, Liam. And I also want to thank you very much for your introduction of of the different models, including what the board model that you were not proposing, but we do appreciate all of your work on that. So thank you very much. John Groveman?
Yeah, I'm trying to. Oh, there I am. Trying to get my camera working. Yeah, so I mean, I just want to. I'll present the opposite framing to Liam because I think that's part of what what I've always done because I just don't see the world the way Liam does in terms of what it would be like if the board heard zoning and activity appeals. But then I'm anxious to get well, my understanding, Brooke, is what you're saying is you really want to then just kind of tease out if we were going to do this how it would work. So I happy to pivot to that. But and just because I don't know the whole LURB, I've never actually appeared before the LURB. But so I'm John Groveman. I'm the Policy and Water Program Director for the Vermont Natural Resources Council. I have a lot of experience with Act 250 and with zoning. I think I've been my DRB chair for. I'm not one now. I'm not there now, but I did it for at least 10 years. I was on the Planning Commission in the town of Marshfield for at least 10 years. I was the A&R Act 250 land use attorney, what they called it back in the day in the 90s, and I participated before the Environmental Commission, district commissions all over the state. I also argued appeals before the old Environmental Board and have argued a number of Act 250 and zoning cases before the Environmental Court. So I've seen the process from a lot of different angles. From my perspective, I think the advantage if you were gonna have zoning appeals and Act 250 appeals go to the board is, I think as we've discussed through the several meetings we've had, I mean clearly, the court is set up, has it's the court process with the rules of procedure and full discovery, and clearly there is concern that cases are not moving, as quickly as people would like to see through the court process, and especially housing appeals, which kind of brought this issue to the fore. The way I see it is that if you have an expert land use board and you have the expertise of a panel of board members who, like you have now, you have a mix of an engineer, you have planners, you have a lawyer, that expertise would result is the proper expertise to look at Act 250 and zoning decisions would result in really fulsome decisions and having a state land use board kind of looking at issues. And I just don't, having, like I said, having served on my DRB and Planning Commission, I don't see zoning and Act 250 as different in the way that Liam described it. I mean, yes, zoning has conditional, like use districts, and zoning has dimensional requirements, which Act 250 does not have. But zoning also, basically it's not usually, if you have a commercial use, you have to make sure that use is allowed in a district. Certainly you have to meet the dimensional requirements, but from my experience, a lot of the zoning issues come down to impacts. Conditional use criteria are impact based. Site plan review criteria can be impact based. Even subdivision bylaws could be impact based. So it's a mix. And I don't think that the impact part of it, of the zoning review, is really significantly different than looking at Act 250. In fact, one of the debates we've had about the appeals issue is how important is consolidating appeals, and that issue comes up often around impacts like traffic impacts, and if zoning bylaws have wildlife provisions in them or natural resource protections in them or other provisions to address the impact of a project. So I just don't see it as that different, and I think an expert panel at the LURB could really bring like a more fulsome review. And then on the efficiency side, for Liam, it's talking about the infusion of resources. the environmental court has 2 judges, and I think each judge has a law clerk. So like that's 4 people basically processing all the Act 250 appeals, all the A&R appeals, all the zoning appeals, doing all the enforcement. And I think that the LURB now has more resources than that. And as Brooke pointed out with the rule, the old environmental board rule, if you use hearing officers and you use panels of the board, you're able to use, I think, resources in a much more efficient way for smaller, if it is an appeal about a dimensional issue, you don't need to put like a full judge on that appeal. You could have a hearing officer do that appeal. If it's an appeal that is raising significant issues under zoning and or Act 250, maybe you want the full board to hear that. Maybe you want a panel of the board. But because you'd have so much more flexibility in terms of the use of resources. I think one of the challenges with the environmental court now, and it's not the fault of anyone involved with the court. It's just, it's basically one judge per case, whatever it is, like whatever case comes in the door, it's judge, and it's the full rules of civil procedure, and it's the full rules of discovery, and it's the full court process. And I think that the system sort of cries out for a lot more flexibility and tailoring the resources that we have in the state, towards the complexity of the case. And the court just is not set up to do that. And I think that the LURB would be. And so I see an advantage of using the land use review board that we set up, both in terms of resources and expertise, to result in better and faster outcomes, for zoning cases. And if the issue, one of the issues is housing, certainly, housing projects could be prioritized, affordable housing projects could be prioritized. And as we've heard through testimony in the legislature about, could you prioritize certain cases through the court system, the courts have basically said, we basically try to move everything through the system in an effective way, and are not really prioritizing. So anyway, so those are the advantages I see. So presenting sort of an opposite, viewpoint that Liam has authentically.
Great. Thanks, John. Appreciate it. Janet, did you want to jump in with a question, or should I take Elizabeth?
Go ahead and take Elizabeth.
Great. Elizabeth?
Yeah, hi, everybody. Thank you. My name is Elizabeth Bridgewater. I'm the Executive Director of the Wyndham and Windsor Housing Trust, and we are developers of affordable housing. I really appreciate the opportunity to make some comments before the full board, particularly because I'm not going to be here for the month of August, so I may not be present at subsequent meetings. I want to build on John's comments because I really appreciated, Brooke, you putting up the numbers again. And I went back and looked at some numbers that you offered earlier up in the process. And I just want to remind us of the problem that we're trying to solve. And that is a way to pave the way for more housing to be built in Vermont and to make it more efficient and easier for developers to get through the process. And so when you look at the appeals that have happened over the last 3 years, only 18% of them are Act 250 appeals, and the remaining 82% are municipal appeals. And so I feel like that is where we should be really digging in and looking for ways to make the appeal process for at the municipal level a major priority of this group, because that is where the hangups are predominantly. I'm not saying that Act 250 is not important. We've gone through appeals on both sides, both with a municipal appeal and an Act 250 appeal. They were both very painful, lengthy processes. But when you look at the big picture of where the roadblocks are, they're happening at the municipal level. And so if we just keep in mind what problem we're trying to solve, I think that really points to looking at that as a major place to make change. And, I'm one of the few folks that are not a lawyer in the room, so I'm coming at this from a different point of view. But as I'm learning from others by sitting on this group, my sense is that the court system has a framework that is fairly set and is not particularly malleable. It's not able to prioritize policy goals in the same way that the board could prioritize policy goals. And it has to adhere to a framework that doesn't really have anything to do with housing. And so it just strikes me that there's more flexibility with the board to prioritize housing, hopefully prioritize affordable housing, because that's where the major need is in Vermont, and just build a system that addresses the main problem that we're having, which is municipal appeals. And then to speak to Liam's comments about the major investment, I mean, as I was listening, I was just thinking about how when we approach a zoning board, and we've approached them in many different towns because we have a very large footprint, we're doing that work. We're assessing the zoning bylaws in each individual town in which we work. We're working with a civil engineer to do that. Our on-site, our in-house real estate development staff does that. And particularly in the project that was appealed in Putney, those decisions that were made at the project level by our staff and by our civil engineer were upheld by the environmental court, the Supreme Court in both cases. So I guess it just doesn't ring true for me that somehow this is a mysterious, not mysterious, but like an unpenetrable amount of work that needs to happen, and a nut that's really hard to crack, because that is the work of developers, that is the work of civil engineers, that is the work of attorneys. And I guess I agree with John that if there's a variety of expertise on the staff at the LURB, that there will be a robust review with a lot of different expertise. So I know, Brooke, I'm kind of wading into territory that you asked us not to, but I just feel like this is the first opportunity we've had to have conversation before the full board. And I didn't want to lose the opportunity to share my perspective as a housing provider and as somebody who's trying to build housing, because I think that is the problem we're trying to solve. And so it feels like an important point of view. So I really appreciate you taking my comments.
Oh, absolutely, Elizabeth. And this is I want you folks to, yes, I'd like to try to get into more particulars, but we can set up other meetings later. I really appreciate all that you've said. It's so important to get all of our perspectives out on the table. So thank you so much, Elizabeth. Janet.
So I did want to sort of reinforce, however, that this meeting was set up to try to envision what the board model would look like should municipal permits be appealed to this board. And so insofar as you haven't had, or you have had the opportunity to express your opinions in terms of the board model versus the court model previously, if we could try to focus on that question, I think it would help us move forward. So, I'm not telling anybody that they shouldn't give us their opinion on that, just that, we want to try to, as Brooke said, build the board model here. And it doesn't mean that we have already decided to take appeals. It doesn't mean that we're not going to. We just need to envision what model we would be considering. And so that was the purpose of this meeting today. Thanks.
Thanks so much, Janet. Annette Smith.
Yes, I'm Annette Smith. I'm Executive Director of Vermonters for a Clean Environment. We've worked in Vermont communities with citizens and towns for 26 years, dealing with the regulatory processes at the Agency of Natural Resources, Act 250. And for the last 16 years, a lot of our work has been at the Public Utility Commission. And so I am here representing the interests of the Vermont public and to some extent towns. Our work has had very little to do with zoning until very recently, when there have been a lot of tower proposals. And so I've had to become more familiar with the telecom bylaws that different towns have, and different towns have different bylaws. The issue that I have seen arise frequently is this schizophrenic land use permitting process we have and decision-making process where the Public Utility Commission has a different set of standards than Act 250. And then we have zoning that has different standards. And so as I look at this new land use review board, I see an opportunity to try and bring things together in one place where there can be consistency in the decisions that are made throughout Vermont, regardless of what type of thing is being introduced, that there is a process that is available to the public, and therefore I am not happy with anything that is going in the direction of excluding the public, and that results in people working together rather than having things forced into communities. On the subject of structure, I noted that was number 3 or 4, so I wasn't going to go there yet, and I'll wait. But I was struck this morning in reading the Rutland Herald. There's an article by the editor about a book written by small town prosecutor. And he quotes the author, whose name is Bob Simpson. I can't imagine people in our country being content with a justice system that is completely controlled by lawyers and judges. Juries are important. And he goes on to quote some more. And that's reminding me a little bit of this, that right now we have a court system that is controlled by lawyers and judges. And our work having to do with appeals on Act 250 has pretty much vanished since it went to the court. We can help people with participating in processes, but the court is something that I think the participation level from the public dropped off tremendously. Maybe that's a goal of developers, but I do see a real benefit in a panel of people who maybe have hearing officers, but that have different expertise that can actually discuss, as this author is promoting, a jury that discusses the issues and can look at things more holistically. And I'm very concerned about this idea that we're going to have these silos of the municipal permitting and heard by court, and Act 250 permitting heard by a land use review board, and utility land use issues heard by a public utility commission. And it leads to tremendous inconsistency statewide. And so I think that the structure of the board does need to, maybe it's not the specific individuals who are on it now. Maybe there needs to be someone in the capacity of a judge, but I think that a land use review board hearing municipal appeals is going to give us ultimately a more efficient process than having it broken up into silos. Thank you.
Thanks, Annette.
Looks like Megan Sullivan.
Oh, he
is
dropped
next.
off. Okay, I thought I saw that.
You did, but yeah. It looks like Megan's hand up.
Megan?
Hi, thanks. Before I ask my question, I just want to reiterate for the whole group, we're all here participating and I think should be coming at this that we are all here with the best of intentions to serve the communities that we are representing, and assigning values or disparaging remarks towards each other, whether it's developers or the vocal minority, is not helpful in moving this conversation forward. So just put that out there. I don't think developers are out there to try and silence the public, but maybe actually serving a less vocal majority. So with that, we just ask, we've talked a lot about housing with exceptional reason. Housing is obviously a critical challenge in Vermont right now. But just wanted to also note that municipalities have zoning over commercial and industrial development as well, and wondering, what the board's thoughts have been or conversations have been about how those types of appeals would be used in this this situation, and what the board would be looking for there. And again, we've looked at what the housing numbers are, but when you're looking at commercial and industrial zoning, what do those numbers look like, and what would that mean for the board?
I guess I'll just respond by saying, I mean, we haven't broken them down into subcategories other than housing, since that was the focus of the charge. From my perspective, it's an appeal, whether it's a housing appeal or a commercial or residential. That's not a priority project. I mean, it's all the same process. And in terms of the, the flexibility of the board, the focus could be in terms of expediting housing. Those are sort of the components that we're looking to try to develop ultimately, to see how, for example, the board rules would be able to put those higher up in the queue or give them an immediate hearing, that kind of thing. I don't know if other board members have any other thoughts about what Megan is asking. Janet?
Sorry. I think one of the questions Megan may have asked is how many permit appeals there are in other categories. And if I recall from your earlier slides, Brooke, this that there were over 100 municipal appeals, and if about 60 of them were housing each year, then maybe we're talking about a little bit more than half are housing. And I don't know if that helps answer one of Megan's questions.
Let me just go back to, hold on a minute. So what we're looking at on this, on these charts are permitting. We're not worrying about enforcement cases. So, and they're categorized about whether or not they're in a town that has on de novo or on the record review. So the total number of appeals of permitting, whether it's housing or industrial, commercial, is in 2022 would be these two types of permits added together. So 66 would be the number. So, there's the other docket of enforcement cases that shoot up the numbers to like the 130 area in terms of incoming cases every year. But incoming permitting appeals is 66 in 2022,
67.
was 67 in 23, and was 59 in 2024. If that helps at all.
Right, but I thought you had presented at one of your earliest meetings some information that showed the total number of municipal appeals as like 110 to 120 each year.
Right.
Is that not the case?
Yeah, but that includes the enforcement cases, which, like somebody's in violation of a permit and the town administrator sends them a notice of alleged violation, that kind of thing.
Okay, so
we're looking at the subset of permits that were denied or issued by the zoning board, DRB.
Right. So I would gather then that we're talking about more than half are housing related.
No,
It's like 23,
No.
a third.
Let me share again.
It's the right-hand column in the table.
Yeah, so of the 66 permitting appeals that happened up to the environmental division in 2022.
I'm sorry, I understand it now. I was just not, got it.
Right.
So how many more?
So it's running, so it's 25. Yeah, 25 were housing appeals. And housing is running about a third of the total permitting appeals. So 2/3, like 40 that year, were commercial or industrial, nothing relating to housing.
So one thing,
Is this-
sorry to jump back in, but just one thing,
No,
you know,
sure.
we would love to be thinking about and looking at is, you know, absolutely support putting housing appeals on a priority, but just want to ensure that commercial, that those other appeals, commercial, industrial, aren't sort of kept on a long-term back burner, that there's still a process and flow that those are going to be reviewed in a timely manner. I think everyone's goal here is to increase time and efficiency in totality, while also prioritizing housing.
Absolutely. And, you know, the more flexibility to impose time frames, deadlines, that's one of the opportunities that this kind of model would provide to us. So hear you loud and clear, Megan. Thank you. That's really important.
So just to mention, there was a question in the room here as well.
Oh,
I was gonna wait.
Yeah.
Okay,
Yeah.
but.
But
you
just-
Go ahead.
Just didn't want you to lose sight of it.
Yeah, so if you want to go in order, go in order. Well,
okay. You let us know when it's your turn.
Yeah.
Yeah.
David Mears is up.
Okay, who do we have? David? David Mears?
Thanks, Brooke. Thanks all. So I mean, on this topic of, the Lord Municipal Appeals, I've spoken on this before, so I'll be brief, but I feel strongly that the LURB should hear those appeals, for a few reasons. There is no entity that ensures kind of consistency across municipal governments in terms of how they apply their zoning laws, or anyone really entity, with the possible exception of VLCT, that can play a role at the legislature to identify the kinds of problems and issues that local governments are dealing with. And having administrative agency / review board in the form of the LURB review municipal decisions, I think would go a long way in that regard. It also, would give, I think you can construct the review process in a way that gives more meaning to local and more empowerment to local governments to make the decisions. The current process with de novo scope of review and de novo standard of review makes the municipal reviews meaningless. So at the same time that I would encourage the LURB to review local government decisions, I would encourage a more deferential standard and scope of review. That has benefits in terms, as we've talked about, and we'll talk about more, I'm sure, that has benefits in terms of efficiency of the process of ensuring that the local voices are heard and matter up through the process, and that the local government's interpretation of its own rules is given some deference. And, they know their communities. And if we don't trust local governments to make those decisions, we have to rethink the entire concept of having local governments involved in land use. So I don't think that's the case. I think we have, historically, given a lot of responsibility to local governments. And so to give that meaning, we need a different process, not just having the environmental court start from scratch on those random cases where the developer or the opponents can afford to appeal to the court system. Also think it creates more opportunities. As John Groban has talked about, the LURB has the ability to dial up the level of review. It can have things that are done informally, through a hearing officer or even an individual member of a panel. It can serve a mediation role, and it can do a full-blown, hearing where it complements, and addresses any gaps in the record left at the local level, so that an ultimate appeal to, say, the Vermont Supreme Court could be handled better. But at the moment, the environmental court, I've been involved, this is purely anecdotal, but I've been involved in 2 ridiculous cases before the environmental court. I mean, I'm arguing against my own interest. Honestly, as a lawyer, there are many clients out there who, and municipalities who are stuck in these cases before the environmental court that are involved things like a shed in a floodplain, or a driveway, a bridge over a driveway, ridiculously tiny cases. It's embarrassing to be a taxpayer and former public official in a state that spends judicial resources on those kinds of cases. We barely have enough time in our court system to handle actually very serious things. Why we send with a complete fresh start with a full judicial process, these dinky little land use issues is beyond me. And the Lord would have a lot of ability to have a more measured and, appropriately calibrated response to that. The last thing I'll say is, and I know there's a whole conversation to be had about the standard of review and scope of review, but I thought the last conversation, the idea that Ron threw out of a hybrid kind of approach makes sense. I tend to be on the side of having a narrow window for additional material to be added to an administrative record, and Ron's argued for something more expansive. But honestly, I just feel like as long as the LURB had the process and there was some mix of giving some respect to the local government decisions, and then the LURB ability to kind of fix it, would go a long way to getting us towards a much more efficient, streamlined process that benefits local community groups, local governments, the state agencies that have to participate in these proceedings, the LURB, the overall process, and the developers would all benefit from this. And to Megan's point, I think it should absolutely fix the whole process. Fixing it just for one category of development and not all of them doesn't really make that much sense. If we're going to go to the time and effort of improving this process, let's do it for all applications. Those are my thoughts. Thanks.
Great, David, and just identify yourself for the record too.
Thank you.
Dave.
David Mears. I work at the firm Tarrant Gillies and Shems, and I am not representing anybody in this other than my own personal opinion. So it's exactly worth what you paid for it. Thanks.
We do appreciate all the hard work that you've done on this, David. Thank you.
Let's go in the room and then back to the hands that are up.
Sure. Hang on just a minute. Online, we have
My name is Jim Half. I'm with the town of Killington. I'm the zoning administrator since, I believe, 2021. I listened into, I believe, your last month's meeting, just sitting in the background. And I saw what the agenda was today, and it's like confusing. Okay, so it sounds like the subject is supposed to be of setting up how the process goes. Okay, and it first starts off with the zoning administrator, that's myself, and then I go through the paperwork, and if it's going to have to go to the DRB, my job really is to sit with the applicant and go through all of our town's zoning regulations and sit there with them and go through, this is what you need to prove to the DRB. And when you go through the DRB, then it is, if the applicant doesn't get a favorable decision, or if somebody in the public thinks that there wasn't favorable to them because a permit was given, from there, it's automatic that it can go to the environmental court. So you're here to start this whole new thing because of, I guess, Act 181, and it's going through, and part of Act 181 is also trying to get some towns to be a 1B and a 1A, and then that takes away from the Act 250 or whatever. So, it's just like what one is going to work, okay, and where are you going to go with this? Because there's, like I believe Ian had said, this every town is different. And so then it could throw in another screwball here, a curveball, that some town could be a 1B or one town could be a 1A inside. And in the town, it's not all 1A. It could just be a certain section in there that is a 1A. So it's like, if you're going to me, it almost seems like de novo is the right way to go. Number one, we just listened to that because somebody wasn't at a meeting before, and I'm not making fun of anybody here or whatever, because I wasn't here 3 meetings ago, okay?
And our salaries are very high for all of you stakeholders.
Yeah, right. So what I'm getting at is it's like, it's, if we're here for the public to give in and for the applicant to give in, then, there's different viewpoints at different times. And just because someone may not have been able to show up to a meeting, if it did go to an appeal or it went to something else. So I'm trying to say, like, it's just confusing. It's like, the project is supposed to be, it goes through the zoning administrator, and then it gets to the DRB if it falls into that town's regulations, that it should go on to the DRB. And if it goes to the DRB with all the public input and the applicant input, and it's not like, yeah, it does leave the town from there. And it goes to, I guess now you're talking about the blurb, okay, that it would go there. But my main concern would be is that to make a town and to provide all of the history, instead of the novo and like it keeping to it, and not everybody's on target all the time or forgets what was said, and maybe one sentence was missed in a minute or something like that. I do think it should be in a de novo situation.
But would you have any objection to the status quo? In other words, there are on the record municipalities presently, and when they go to the court, it's an on the record review because they have agreed to take on the responsibility of, keeping track of it.
But that gets back to like Ian was saying in the beginning, where each town is different, and that's what you're saying too. The town of Killington is de novo. Okay?
Right. So you would want that to remain de novo.
I would want that to remain de novo on that point.
Sure.
I mean,
Yeah, the only difference that we're talking about really is where that appeal goes. Does it land at a
yeah, but
court?
that's what I had said. Like,
Yeah,
I think right now it goes to the DR, after the zoning administrator, it goes to the DRB. And then,
We're not
if you
changing
want to have a fair, no, what I'm saying, if you want to have a fair, whatever, either side, it should then leave to me, it should, and my DRB group would probably kill me hearing me this saying this, but I think it should leave and go to, another set with the public and the applicant still going there, but following certain rules. But then you throw in 1A and 1B, and it kind of takes.
Janet or Sarah, do you want to respond at all to the notion that 1A and 1B has an impact, or that we should be considering that on zoning in and of itself? I
think it wouldn't have too much impact on the total number of appeals between municipal and Act 250, because there aren't that many Act 250 appeals relative to the municipal anyway. So if there are exemptions to Act 250 within Tier 1A and Tier 1B areas, I don't think it would have that much of an effect on the volume of appeals, if we're talking about both together.
But 1A takes Act 250 out and puts it onto the town.
Yeah.
Right.
To do the hearing.
Well, what it does is if the town, assuming, obviously they would need their subdivision bylaws
Right.
to get that status,
And
right?
finding one.
So, but this isn't impacting the zoning process. Now, I think there may be an argument that it could possibly increase the number of applications because we're trying to encourage housing.
Right.
And perhaps the number of appeals of zoning cases could go up. That's conceivable. But at the same time, we're talking about not then requiring Act 250 permits. So the net, what we have sort of decided is the net impact is difficult and speculative at best. So in terms of, we're trying to figure out based on history at this point and figure out what board model we're going to create, because if we have flexibility to handle more capacity, if that comes to fruition and numbers do end up going up, then we at least have a strategy to deal with that by using the panels, hearing officers, et cetera.
Yeah, and just every town, I'm just gonna stick to my last, every town is different.
Right.
And like you take a town of Burlington or whatever, a city like Burlington, and the members that you have on some of these boards, DRBs or whatever, are maybe a lot more qualified than in another, and it's not personal. They follow the rules straight. And I've been into a couple of DRB hearings where it could wander off or whatever to where it's
Right,
not
right.
supposed to.
Yeah.
So
Yeah.
you know, to me, I'm just saying that I think everyone, if you're gonna take it to a further case, whichever route it is, that it should be de novo, because it should give the public and the applicant in case they drop something or miss something. That's it for me.
Okay, thank you very much. I appreciate all of that information. Paul Connor?
Just 1 second. Hi, folks. Thanks for taking the time. My name is Paul Connor. I'm the Planning and Zoning Director with the City of South Burlington, and I've been in this role, let's see, next week it'll be 17 years. I'm going to try to stick to what the request was, which was to talk about the possibility of a board review and not try to get into the debate of the two different methods today. And I'm not an attorney, so I'm going to sort of speak a little bit generally on some of the characteristics that I'm seeing sort of coming up and what the board might want to be thinking about in terms of opportunities for prioritization. So first of all, I appreciate the dive into the e-court work on numbers of appeals and numbers of appeals of housing. I'd encourage that also consider the scale of those appeals, because an appeal of a single unit building versus an appeal of a 80 unit building or a neighborhood of 150, it all comes down as a single number. But if part of our discussion here is really about housing overall in the state, those are very different implications. And so how could a system if the laser focus is on getting more housing built, thinking about it in those ways as well. There was a little bit of discussion a minute ago about Act 250 Tier 1A, Tier 1B through the Act 181, and I think we're probably going to see a lot more projects that only go through the municipal level. At least in communities that take advantage of Tier 1A and to a certain extent the Tier 1Bs also. So that may not change the volume of appeals, but it'll certainly change the source of the appeals. We'll see more examples where they're taking place of the municipal. I think that's generally the case already. It's rare that something that we've seen, at least in our community, gets appealed at Act 250, but not local, although there is a case that went all the way to the Supreme Court just got decided a couple weeks ago that was only an Act 250 appeal. Sort of connected to my first point, and as we think about the broader purpose of Act 181 and its predecessor, Act 47, about targeting development and housing into certain parts of the state, areas where we have infrastructure, areas where we have our historic downtowns and things like that. How could an appeal process reinforce and reflect those priorities? So, are there ways in which, if it's in a Tier 1A area or a Tier 1B area, and the community has done its homework and the state has said this is where we want to have infrastructure, how could an appeals process support expediting work in those areas, just like all these other tools that we're doing statewide are? Sort of connected to that, often what we see, and I think this happens statewide, those who choose to make an appeal are really interested in appealing projects to the fullest extent possible. Their goal is to not necessarily altruistically say that they want to just make sure that the first decision was right. They believe very strongly that their viewpoint is the correct viewpoint and bring it all the way to the end. I'm not making a value judgment with that, but I would be curious. I don't know a lot about the hearing officer process. I'd be curious whether the result of that will be that issues get settled, or is the result of that whoever feels, who took the appeal feels like now they need to bring it to the next stage and the next stage after that. And so I guess I'd consider, what are the implications as to what happens after that adjudicating body makes their choice, and what is the likely implications of that. And then lastly, this is in a little bit of a different category, but one of the interesting things about Act 181 in setting up the Land Use Review Board is that it's a board with more than one role. It has the role potentially, as you're discussing here, of a board review. It does some level of oversight of Act 250, and then has a role in regional future land use maps, which have a role all the way down to municipal plans. And as you think about appeals, I'd also, encourage you to think about how does that affect overall workload for the Land Use Review Board and its ability to do the other parts of its work, and how does it over time shape the makeup of that board and sort of its job. So as a local municipal planner, the thought that's coming to my head is it's a little bit like, and understood this is not a perfect example, but it's a little bit like the dual role of Planning Commission and Zoning Board of Appeals. You're being asked to do two different jobs potentially, and how do you balance those jobs both in terms of workload but also in terms of like temperament and approach? And just give that consideration as you go through your process here. Those are my notes. Thank you.
Well, thank you very much, Paul. That's very thoughtful and interesting. Who do we have next? Samantha.
Hi everyone. Brooke, you'll please feel free to interrupt and tell me if I'm having a connectivity issue. I'm getting little notes from my computer about that. I could switch to off camera, but I'm attempting to use my camera. So thank you. Okay, great. So I'm Samantha Sheehan, the Municipal Policy and Advocacy Specialist for the Vermont League of Cities and Towns. Have a lot to say in reaction to prior comments and to the concept and work that the board is doing on this topic in general, but I'm going to try to condense those comments. And I want to start with sort of a big picture of VLCT's position for those members of the board that may have not heard it yet. So the league does not have a member endorsed position in favor of or against the board model or the hybrid model. We're very open to hearing the so far well articulated and really thoughtful comments both in favor and against this change. What our interest in is in supporting as the statute says, a more efficient and effective system for appeals, and one in particular for our interest that enables the type of development that local communities need, have envisioned through community process, and have made legal through their local regulations. So to sort of specifically address the board model or the hybrid model and how it may or may not sort of meet those goals, we're really concerned about capacity. Those questions have been raised. Certainly the volume of appeals to date before 2024 have been coming from or against municipal permits, and likely that will continue, and the volume of municipal appeals will only increase as Act 181 and the new CHIP program are fully implemented in the future. I want to say that capacity could be addressed through the creation of the board or the choice to resource it through hearing officers, attorneys, and other types of administrative help. It could also be addressed by changes to the law that decrease the overall number of appeals and support the other goals of Act 181. And that we could be also talking about standing for appeals, about how to improve the deference to the local regulation. We could be talking about what is appealable within the areas of a municipality. And sorry, I lost my train of thought. I really like that we got to hear today from more than one local official that works in planning and zoning, one of our many hundreds excellent municipal officials who administer this work. But that is not who makes local regulatory decisions. State law requires a long, robust, citizen-led, and democratic process that creates bylaw. And then it's up to the administrator and the appropriate municipal panel, which is a lay panel of citizen appointees, to decide on the application of that regulation at the local level. So then when that decision is appealed, it makes sense that there be improved deference to that local regulation in the appeals process. I want to get more weedy now and talk about Tier 1A. So we have this concern that under the board model, a situation is likely to happen. It's likely to happen quickly, where an appeal of a municipal zoning permit comes to the LURB within a Tier 1A or Tier 1B area. And really, in the future, under the location-based jurisdiction, no matter where a planned and permitted development is located, by the time it is permitted, the LURB will have already acted under its statutory authority to determine the Act 250 jurisdiction for that project. So they've already exercised that statutory authority. If the planned and permitted project is in a Tier 1 area, then the LURB would have also already acted and made a ruling on the quality of the local regulation. They would have already tested the zoning and bylaw against the statutory criteria to achieve Tier 1A. And so I don't think it's important at all if I perceive a conflict of interest there for the LURB. I think it's really important, or VLCT thinks it's really important, if the appellant or the other parties to the appeal perceive that conflict and what that may do and what the unintended consequences of that change in the appeal system could have. Because if we follow our sort of mandate as a stakeholder group under Act 181, we're looking to recommend an efficient and effective appeal system. We would not want an outcome that creates more and greater opportunity for appeal within the Tier 1A areas, where the state, through the authorities of the LURB, have already determined these areas are both appropriate and desired for density and growth, and where the particular municipality has the capacity in-house and has the right regulation to meet this standard. So I went, high level and low level, but I think there's a lot of ways that could be solved for and still change to the board model. But I think for us, those changes need to be clear, and that potential conflict needs to be sort of aired out and understood.
Sarah, do you have any response on that? I do not necessarily, the characterization of a conflict of interest, I don't think is necessarily the appropriate term. It sounds to me like the concern is how much authority that the LURB has. And in terms of, approving the work of the regional planning commissions and the towns, we certainly have a role to play in terms of assessing whether or not regional plans and, Tier 1 mapping is done according to the statute. We, have that role to play as a safeguard to make sure that there's consistency and that all of the boxes are checked. And it has an easy way to say it, but we are not making those substantive determinations. And all it is, I mean, this is mapping that then removes the LURB from any kind of decision making on Act 250 within these same geographic regions. So so I'm going to turn it over to Sarah if she has anything to add to my thoughts about it.
Sure. I think we've been getting a lot of good questions about the Tier 1A process and what it's going to mean for municipalities to administer the Tier 1A process once they receive approval for that area. And so I think first and foremost, we need to get more information out about what we expect that to look like. For right now, there's a lot of good guidance in 24 VSA 4460 G and H. And so what's laid out there is a municipality would be issuing their own decision within the Tier 1A area. So in effect, if there was a decision that was appealed, it would be a municipal decision that then would come back through this process. Now, I think what I also want to reiterate is something that I heard attending another one of these appeal sessions is the board will have to do its due diligence in terms of firewalls. And that is something that will be looked at later and is a very important part of the discussion. I would agree that the perceived conflict of interest can be as harmful as an actual conflict of interest. And I think that that's on the to-do list for us to do our due diligence in that arena. So I'm happy to take something more specific, Brooke, but I'll just leave it at that for right now.
Brooke?
If I could
yeah.
just quickly respond, sorry.
Well, can I, Samantha, can I just respond to something that you had said about
Yeah, great.
the because the board is making a judgment about whether the local regulations I think you said are meet the qualities, or maybe said good quality or not to meet the tier standards. If municipal appeals came to the board would not be the board would be administering the local regulations as duly adopted. And so I'm wondering if your perceived conflict is that is the characterization that the board had determined that the local regulations were not of good quality, which isn't exactly what the board is doing. What it's doing is it's determining whether the local regulations meet certain statutory standards. Does that
Yeah,
okay,
correct. But and contained within the statutory standards are smart growth principles, flood hazard mitigation. I mean, the list is enumerated. So you're taking the local process creates prescriptive zoning in the local regulation. The LURB is acting to determine Act 250 jurisdiction and ruling whether or not the municipal regulation meets the standard of the law to achieve that jurisdictional determination.
Yeah.
Also, the LURB is ruling whether the map is consistent with the regional plan and the other statewide goals as they relate to tier 2 and tier 3, or tier 3 and then tier 2 is created, right? And so what I had wanted to respond to was, I think my concern that I'm expressing, just to be really clear, is not about the amount of authority at the LURB. It's about the relationship and process between implementing the location-based jurisdiction and then potentially serving as a venue for a fair appeal process. And that is different. That will be different. Right now, like, we took a very binary path of permit authority and appellate body authority. Currently, we've bifurcated that through the temporary exemptions. So it's very clear inside the temporarily exempted area, there is no Act 250 jurisdiction. It's the permit authority rests only with the municipality with no change to the appellate body. And now we're contemplating changing both of those systems at the same time. And where those changes will intersect is really important, I think, to work through and understand. I haven't even gotten into the requirement for municipalities to enforce existing Act 250 permits under that system, which I think Annette raised concerns about in the last meeting, and I think are really smart complexities to point out. So that's all. It's not about the concept of the authority resting at the LURB. It's about how those two authorities play out in reality in the new system.
I think it's a little bit like Paul posited with the ZBA planning commission model versus a DRB model. That
Yeah.
So yeah, that's a similar characterization. Thank you.
Thanks. Mira?
Hello, everyone. My name is Moreau Weinberger. I am the executive chair of Let's Build Homes. Although my comments also informed by having served as the mayor of Burlington, Vermont for 12 years. And before that, as an affordable housing developer who unfortunately had the unpleasant experience of interacting with the current and prior appeals reform system. Just by quick way of Let's Build Homes has not participated in the stakeholder process up until now. We intend to continue to do so going forward. So since this is my first time appearing, let me just say quickly, Let's Build Homes was launched in January and has quickly become a statewide organization representing hundreds of Vermont organizations of all sizes, employers, institutions, municipalities, in some cases, municipal officials, as well as over 800 Vermonters. And the kind of guiding belief of Let's Build Homes is that Vermont faces an acute housing shortage, and that shortage is driving not only high levels, very high levels of homelessness and rent and home unaffordability, for sale home on affordability. It is really a driver in most, if not just about all, of Vermont's major social and economic challenges. Certainly anything related to the workforce, as we see in the both with our businesses, our hospitals, our utilities. The lack of housing is a major driver of our current challenges. I apologize. Somehow this moment is when my fire alarm system is testing itself. Hopefully that will stop in a moment. Let's Build also believes that this shortage is something we have largely imposed upon ourselves over the last 25 years through the series of state and local policy decisions that interact with each other and build on each other in problematic ways. And that this is a problem we can fix and need to fix, must fix if we want a bright future for the state. Appeals reform certainly is necessary to achieve that housing abundant future that we need. I appreciate the statistics shared here about the number of municipal appeals. I think those are very interesting. I would encourage the board not to see those numbers as the totality of the current appeals problem. What those numbers do not capture, cannot capture, never will capture are the large number of projects that never move forward because the chilling effect that the current appeals process has on the willingness of nonprofit and for-profit builders to attempt to navigate their way through the current land use regulatory process. I say that from hard experience of having taken a project in Burlington that we started to be attempted to try to secure permits for starting in 2002. We did not receive a final adjudication from the Vermont Supreme Court until 2008, and resolved never, my business never attempted again a project that had to go through the Vermont appeals process, having lived through that. And I think there are many other, surely are many other individuals and firms that make the same calculation under our current system. I will say when we did go through that back in 2000, the appeals played out in 2003, 2004, 2005, 2006, 7, and 8. We were very grateful for the then recent consolidation of the process, so that both the Act 250 appeal and the local appeal went to the same body, and we did not have to go to yet another stop to get the final outcome on that project, which was ultimately successful. And the project is built, I should say, and 25 households are living happily in that project now. Had we had to go to another stop, the environmental board as well as the environmental court, I think we may well have given up on it. And I do go into this process really, no matter what outcome, I think it would be terrible if that consolidation was undone, and yet and projects that were, as we heard from the South Burlington planner, when opponents throw everything they can at stopping a project, if that now involved the ability to force a project to go to yet another board or court through the end of this, that would be really an undoing of one of the few positive reforms of changes in the appeals process that have taken place in decades. That said, I understand that there is real interest in exploring whether the LURB could play a role in this, and I respect the opinions of others that we've heard from here on how a board process could be superior to a court process. So, in what I share now, I offer in the hope that it could be possible for a model board process to be set up that improves the situation. And I would offer these principles that Burlington used over the last decade to improve its permitting system, which has been largely successful. The number of projects, housing projects that are happening in Burlington now is larger than any time in recent decades. And those projects generally have not been appealed because of the new systems that we have put in place. And those systems did the following. First of all, they eliminated subjectivity. Burlington used to have a subjective character of the neighborhood test and a subjective parking waiver system that most projects of any scale needed to go through. Those were the favorite topics of many appeals in those past. We have moved in some ways to a more prescriptive Burlington code now. It is a form-based code. It has a lot of rules. Some builders, developers, architects find it to be too micromanaging, but the trade-off for that is, in return for those additional rules, there's predictability and there's clarity, and Burlington municipal permits no longer get appealed the same degree. It's sort of the flip side of the same coin. Maybe it's just repetitive, but I do think saying it this other way is helpful as well. We should seek to have the type of development that we want more of, namely housing, different forms of housing that there is a political consensus that we need more of. That should be by right and should not be subject to appeal at all. And we now have a form of that throughout the city of Burlington as well. In the neighborhood code has attempted to make clear that housing under a certain scale is a property right and cannot be easily appealed anywhere in the city. I think that is a little untested so far how that will work, but I think that's what the legislature was seeking in the Home Act, to try to make more density at a certain scale essentially required throughout the state. And I think the LURB could do a lot to, in this process of laying out a new appeals reform system, you could bring those principles of housing being a right at certain scales, and that scale could vary depending on the community. And you could you could ensure that you move away from subjectivity whenever possible in the way these rules are written and adjudicated. And I do think, final point, just there are increasing number of examples around the country to look to of jurisdictions that have successfully done this. My understanding is just down the road in Hartford, Connecticut. And I don't know the details of this as well as I'd like to. But all housing projects are bar right, is my understanding now. There's not even a public hearing when a housing project is involved. And thus there's nothing to appeal. And I think a number of other states are moving this direction as well. And again, the goal is not, and I want to be really clear on this, the public input, public debate, the public needs to be the driver of what policy should be with respect to the amount of housing, the scale, the intensity of it. However, once the public has done that and acted through its legislative bodies, or its city councils, or its mayors, and other city officials and state officials, that policy should be set and then should not be relitigated literally on a project by project basis. That's the system we have currently. It is has a terribly negative impact. It is a major contributor to our current housing shortage. And I hope that no matter what the outcome of your process is, you move us away from that project by project litigation of what should be established policy. Thank you.
Okay, lots to think about there. I'm not sure it's, much of it is perhaps in the other category of other permitting suggestions. So since we're less than a half an hour from our final time, I would like, especially for people who have already spoken, to please let's focus back on building a board model and the component structure, whatever you guys want to talk about. If you want to let us know those particular specifications, we're happy to hear it. And Brian, you are next with John Groveman.
Brian Bannon, Town of Brattleboro, zoning administrator for the last 16 years. And the type of review came up before and people were speaking in favor of de novo. I wanted to speak in favor of on the record review. Brattleboro has had considerable success with that. It's strengthened our local review process. It's made it more professional, and it's made it open to the public in a way that Act 250 hearings can't be. And it's given a degree of finality to the board's deliberations. And because of that, I think we're seeing fewer appeals, and when we do see them, we're seeing them resolved more quickly. So I would like to speak in favor of that, continuing as it is with the status quo. And I think when you examine the administrative capacity for Tier 1A, you should definitely consider requiring on the record review for those communities. And that's it. Thanks.
Oh, interesting idea. That's the first time I've heard that, as opposed to status quo. If you're going to Tier 1, you go on the record?
Yeah. I think if you're delegating authority for what would formerly be Act 250 projects to local communities, then the communities should really have the power to hear those and act on them in a final manner.
Excellent idea. Thank you, Brian.
Thanks.
John Groveman.
So I'll be brief because I want to, there's some people who haven't spoken, but I just, in terms of something that what the review could look like, and this has come up with a couple of speakers, and I wanted to, if the board hasn't looked at it, and if other people on the call haven't looked at it, VNRC proposed that in 1B areas. I mean, what I heard the last some of the speakers say is that if you have comprehensive planning, you shouldn't you shouldn't have like an appeal that appeal should be limited in some way. And VNRC agrees with that, and we look at the 1B planning in particular with the focus on housing as a comprehensive planning process. And if you go through that process, I suggested in what I wrote on behalf of VNRC, could we really limit appeals of those projects to basically just make sure that it meets the dimensional requirements of zoning, sort of the basics of zoning. And I do think, though, that it has to be only in areas where you have the comprehensive planning review. I don't think it makes sense to basically say a housing project anywhere in the state should not be subject to a review or an appeal. But if you go through the 1B process, I think that makes sense. And so I just wanted to direct people to look at that part of what VNRC has written. And because, I do think that is a way, whoever heard appeals to basically get to housing in where we want it in these dense areas. And just the last thing I'll say I won't belabor it now, but maybe I'll submit some written comments. But on the sort of perceived conflict of the board designating 1A and 1B areas, I just don't see. They're very two different issues. The work of determining jurisdiction and just making sure that that a municipality qualifies for the 1A designation or the 1B designation is not the same as like a project review. And it would really be in 1A. Like I said, in 1B, I think that you could have a very limited review. And if there's a limited review, there's not much to appeal. But I just don't see like a project review in 1A just because the board said, well, you qualify, your zoning is comprehensive enough to have 1A and you meet the other criteria, that you can't review a specific project against whatever their criteria are that the town has for zoning. They're really two different things entirely in my view. But I'll stop there because I want to give other people a chance to speak with the remaining time we have left.
Thank you, John. Appreciate it. Kathy, how are you?
Good afternoon, everyone, and thanks so much for all the work you're doing. I'm from Evernorth. We are the largest multifamily developer of affordable rental housing in the state. Okay. And unfortunately, we probably have been through more appeals than any other developer in the state for housing. So our interest is to see if we can design a more timely process than what we have right now. And I believe one of the speakers talked about the great degree of difference between the complexity of appeals, whether it could be a small housing development or it could be a major expansion of a ski area, but yet we all are put into the same framework. And that is why I'm very interested in this concept of the administrative hearing officer and using the LURB for municipal appeals, because I think it might allow to tailor a process that that mirrored the complexity or not, or maybe more straightforward appeals. Evernorth is a partner with Wyndham and Windsor Housing Trust on the Putney project, and I know I'm a real estate developer, but the appeal related to the zoning ordinance on that project was not complex. It was very straightforward. But yet it took quite a bit of time to make its way through the environmental court. So that is why I'm very interested in whether this concept of using an administrative hearing officer and engaging the LURB in municipal appeals might help us advance this, getting to a more timely resolution of appeals. Thanks.
Thanks, Kathy. Holly?
Holly Major, the Policy Director for the Vermont Housing and Conservation Board, and much of what I would say has been said by others on this call already, just the need to have a smooth, quick, and predictable process, especially for housing appeals, especially those where we have public funding at stake in those deals. You asked us to think about what a ideal board model might look like, and I see one of the advantages of the board model and the ability to prioritize housing. So when designing a model, would want to look at doing so in a way that does have that prioritizing mechanism within it. We've heard concerns about the capacity, especially of the LURB, to hear these municipal cases, because there's more number of them than the Act 250 cases. And I think when we look back at the policy conversations around how to expedite housing appeals, the ask from the courts has been to have additional resources placed in them to move cases forward more quickly. But going through the courts, you cannot prioritize, you cannot link the increased capacity to the outcome you want to achieve, to housing cases being prioritized. And if you go through a board model, you still need to add capacity, but we need to add capacity either at the courts or in the board to move these cases forward more quickly. If you do it through a board, then you can layer on that prioritization. And I see that as a real advantage there. Finally, I just want to kind of ask that this group pick up at some point the conversation that both John Groveman and Mara Weinberger have lifted up around housing by right, especially in our areas that have gone through extensive planning processes that have been designated for growth. I think there's a really interesting intersection with the appeals conversation, because if we are able to minimize the governmental decisions, the permits necessary in our growth areas, we could help lighten the load and the number of appeals that are moving through a kind of newly envisioned system. So I think there's a natural intersection between these two policy conversations, and be exciting to explore what that might look like moving forward. So thank you for the work.
Thank you very much. Now, what time is it?
2:41.
Okay, we got 20 minutes left. Before I have a couple questions that I was going to float for some quick survey or quick responses to see if people are generally in agreement. But before I do that, I'd like to ask the board, is there anything that our board members would like to ask or talk about before I kind of do a couple cleanup questions? Anything else that you'd like us to ask some further questions on? Janet?
I guess I'd just like to ask everyone present, if the board were to take appeals, what additional capacity in terms of staffing people think the board should have, numbers, I guess. I think that's what we're trying to understand, from those who are more familiar with the appeals process than some of us on the board are. What additional capacity in terms of full-time equivalents and do you think we need? It sounds like with a board model, people really do like the idea of an administrative hearing officer option. But beyond that, what are the numbers you think need to be added to our program?
David Rue.
Hi, yes. I'm generally against this idea of the LURB taking on zoning appeals.
Hey,
However,
David, introduce yourself first so that we know who you are, because not everyone knows you.
I'm Dave Rue from SB&F Attorneys, formerly Stitzel, Page and Fletcher. I have a relatively active land use and zoning practice, generally representing municipalities and regional planning commissions throughout the state of Vermont. I was a clerk in the environmental court and have worked in private practice since roughly 2007. Generally against the idea of the LURB taking on zoning appeals. If it is going to go that route, I think it really needs to staff up on attorneys. As someone who provides advice to municipalities and zoning administrators on a everyday basis, there are some highly technical concepts and theories in zoning law that require a lot of research and a lot of checking. And, you know, having one attorney on the board is very likely to be insufficient to handle that load.
Thank you very much. David, nice to hear from you. Who's next? Liam?
Well, again, to reiterate, I don't support the idea of the board handling these appeals at all. I think there is an inherent conflict of interest. I think the board is in the position of writing the rules, providing advice to all of the commissioners and all of the district coordinators of how the rules should be interpreted, and then to turn around and be the appellate body to review and decide upon its own rules that it has decided is an inherent conflict of interest. We do generally have a legislative body and then a judicial body, and I think those are separated. In order, I think the other thing that has not been discussed here, and we can't divorce this, is that when there is going to be a decision about the various tiers, there will be a substantial portion of the state of Vermont that will be covered by requirement that an Act 250 permit get built for every driveway, every house, every development in tier 3. I think the amount of appeals and permits that are going to come out once those tiers are decided is enormous. And I think the board is going to have a difficult, all of the commissions and the board are going to have a very difficult time over the years after those tiers are made, because of the broad nature of the jurisdiction then of the commissions and of the board itself. In terms of appeals, we have 2 environmental judges who have spent together probably 50 years of their lives focused on the issues surrounding local land use. I think I just don't think that this is going to be something that we're going to be able to hire a hearing officer and have them deal with the complexity of land use. There are 2 judges. There are a series of also staff. I think, you know, you're going to need at least 4 or 5 hearing officers and additional staff to support those hearing officers. So I think, you know, the board has the possibility of ballooning into a very large administrative body very quickly over the next few years, if as this jurisdiction expands beyond the tier 1 to tier 2 areas, and if it decides to do Act 250 appeals, municipal appeals on top of that.
Okay, Liam, I'm going to respond because I straightened this out the last meeting and you've repeated it. And it is not the case that the Land Use Review Board micromanages anybody or tells any of our district commissions what to decide, or our district coordinators on jurisdictional opinions. We govern the process, and statutory authority resides with the district commission and with the district coordinator, depending whether it's permitting or a JO decision. So to suggest that we are involved in telling them what to do, that is not the case, at least as long as I have joined the new board. Perhaps in the past there was a different structure, but I want to be really clear about that, because I don't think it's fair to characterize what we are doing as an automatic conflict of interest because we're not operating like that. So I
Well,
want to be
yeah,
just crystal
let me
clear on that.
respond. Let me respond
Yeah.
to that. You guys are going to write the rules. Then you're going to issue, there's a policy manual, a training manual that every board member and every district coordinator reads and goes by. And then when there is a question as to interpretation, it comes back to staff in the board, and therefore all of
No, hang on, Leon. It does not. It comes if they need legal assistance. Our general counsel is requested for assistance, and she assigns a lawyer to that. The LURB has absolutely no information and is not involved in that process. If they need legal assistance, we have legal staff for that, and we are contemplating how to isolate that lawyer if something that they assisted on or gave legal advice, et cetera, to conflict them out or recuse them from operating and create the firewall that way for the lawyers as well as for the LURB. I just want to be really clear about that because I think you're blurring the lines here a little bit.
No, I experienced how it worked and still works, and I don't unless there's a dramatic change with again a massive increase of staffing so that you can isolate the parties. I think there is going to be this inherent conflict of interest, but I do think the bottom line is the question was, are you going to need more staffing? Yes. And are you going to need a lot more staffing when you have jurisdiction over a large part of the state, every development in a large part of the state? Absolutely. And I just don't think the board's going to have the ability to handle all of this.
Okay, Liam, thank you. Appreciate your thoughts on it. John?
You skipped Samantha.
Oh, did I skip Samantha? Samantha was number one. I didn't see her there. Samantha?
Thanks. I think Liam, it was Liam who just spoke, makes a good point about the likely increased volume of Act 250 permits within Tier 3 in the future under the enhanced regulation there. It strikes me in looking at the early preliminary regional maps that the most land area in the state available for development, in particular in residentially zoned districts, or in areas of the state that already have residential housing, will be Tier 2. So those future projects will be subject to both Act 250 and, in 150 cases, municipal permits. And we know already that since 2020, there's been a real change in development trends here in the state where we are now permitting more multifamily developments than single family developments. So for these reasons and others, including the Home Act, which created density preemptions in downtowns and transportation corridors, and CHIP, which creates new municipal finance authorities to enable infrastructure and housing, regardless of the tier, we're really anticipating an increase in both permit volume and an increase in the complexity of projects that are being planned and permitted. I'll quickly share an anecdote on a totally different policy track. The state is working towards regionalizing property valuation. They were looking at the appellate system for a new regionalized property valuation law. And we quickly, throughout the legislative debate, looked at the real today appeal rate for both a level 1 grievance and then an appeal to the body. We looked at the parcel count per region or per county that was being proposed, and we determined pretty quickly that a single body was not feasible to hear the appeals at today's appeal rate. So I think to answer Janet's question in a more straightforward way, if the LURB were to begin to hear appeals of both Act 250 for both Act 250 and municipal permit appeals, starting in 2027 or later, I think that would necessitate the ability to hear, there would have to be concurrent moving hearing bodies, right? Like you couldn't have a single decision-making body taking on 300 municipal permit appeals a year. That's not going to be feasible, and it may be 500, maybe 600. So you'd have to be able to have multiple venues moving at the same time to accommodate the volume. And I think that's even more important if we're looking at the model that begins with an administrative judge. I think absolutely it's not administrative judge, it's administrative judges, just to take on the likely change in volume. But I think there's a way to sort of practically figure it out, understanding how many units of housing, how many permits are granted. We roughly know through census data, we can determine the rate of appeals 2020 to 2025. We can accept the state's housing goals 25 to 2030, and we can try to understand a sort of maximum workflow for the future appeals venue.
Okay, we have two more folks and then we will be out of time. So I'm passing it off to John Groveman and David Mears.
So I think you'll need more staff, but not a lot more staff. Liam said you have one attorney. I believe you have 3 attorneys. As I stated earlier, the court has 2 judges and 2 law clerks. The LURB, I think what Liam also and other people ignore is that the LURB is a professional board. You all are full-time paid employees. And the way it works at the PUC and the way I think it would work at the LURB is the lawyers could be hearing officers. The LURB members could be hearing officers. You could have panel. The lawyers could write decisions. The LURB members could also write decisions. So I think right now you have 8 people who are capable of being involved in the appeals process as opposed to 4 people at the court. Maybe you'd want to add another attorney or 2, but to say that you need to like double your staff or some monumental increase in staff is just makes no sense whatsoever. Brooke presented information at I think it was 2 meetings ago about how many matters that the PUC handles with if you look at the percentage of staff to matters. I would encourage the board to look at that, because I think the statements about the level of staffing are just exaggerated and not accurate. I wish that VNRC fought for the tier 3 designation, and we have been fighting against this perception that a giant chunk of the state is going to be tier 3 to protect our most critical natural resources. And I think, as the board knows, that because the board is writing that rule, it's going to be a pretty focused and narrow set of our most important resources, and not going to result in an explosion of jurisdiction all over the state. So I don't think that is accurate. And so I think the jurisdictional scope will not change greatly. You're going to have some contraction in the 1A and 1B areas. You'll have some additions with whatever tier 3 turns out to be. And I think you're looking at maybe a lawyer or 2 to go along with the LURB staff.
Hey, John, thank you very much. And David, if you could bring up the rear.
I think to answer your question, Janet, keep in mind that the goal is to reduce the amount of time and effort and expense. So comparison to the environmental court isn't necessarily apt. I think you could probably do it with 1 additional attorney and the existing staff that you have. But with that, I'd recommend 2, in part because I think there's an unmet need that isn't currently being met by the court, which is to assist in the smaller cases where there's a neighbor versus neighbor appeal or a small scale dispute, that having an informal mediator available would make a big difference. So if you had 2 hearings officers, you could have one that can be assigned, and they can both be trained as mediators. One can be assigned to help mediate and resolve small scale issues. And in the event that that's not successful, then it can be referred to the other hearing officer to do a more formal appeal. Another thing to consider is that the whole point that, what part of the design that I'm recommending is that it not be de novo, either de novo scope of review, meaning don't consider all you have to get to start fresh with a whole new round of discovery and everything and presentation of exhibits and witnesses and all that. It shouldn't be able to start fresh in front of the LURB. So the scope of review is not de novo. It's more limited, starting with the premise of that the bulk of the record should be what was developed at the Act 250 District Commission or the local government. And then the standard of review should also not be de novo, that there should be some deference given to the decision of the district commission or the local government. Those two things alone, changing the standard and scope of review, will significantly reduce the amount of time and effort spent to resolve the appeals. So I think having 2 hearings officers would be sufficient. The last thing I'll mention, to build on something John said, the LURB itself can be the appeal body. I could imagine having 3 tiers of cases, that you have rules that kind of designate these. There's going to be small, intermediate, and complex. And for small, they may be resolved through mediation or a very quick hearing before the Land Use Review Board, or maybe you even want to delegate some of those to a hearing officer just to try and give them full authority to resolve them without going to the LURB. So it's a one step and then off to the Supreme Court. Then you'd have at the other end of the spectrum, the complex cases, and those would absolutely be the most important ones to refer to a hearing officer to do a full-fledged, process to make sure the record was fully developed, that the package of the administrative record was fully presented to the LURB for a final decision and then appealed to the Vermont Supreme Court. But the intermediate cases could be heard directly by the LURB itself. There could be a set of cases that are, as a routine matter, heard directly by the LURB, perhaps with a hearing officer present to help advise you through any issues that come up during the hearing. But you wouldn't need to have a separate whole hearing for the hearing officer. So the short answer is, I think probably 1 hearing officer would be sufficient, but I would recommend asking for 2.
Terrific. Thank you so much, David. Thank you all for all of your time. And I will now pass the meeting baton back to our chair, Janet Hurley. And I think that all of our public members have had an opportunity, Janet, but you may want to just do a last call for public comments.
Sure. If people don't mind going over a few minutes, if anyone who isn't a member of the stakeholder group would like to comment at this time, please do so. I don't see any hands going up. And we did have public comment throughout this meeting, and I thank those who offered that, stakeholders and others. But thank you, everybody, for participating in this sort of extra stakeholder meeting of the board. The board really feels like it needs to get as much information as possible to give direction to Brooke as she drafts a report. So this has been very helpful, at least for me. So thank you very much for all your input. And Brooke, do you want to announce what's upcoming for appeals?
Sure. We have our next meeting is July 29th, which is going to be focusing on environmental justice, ombuds office, idea about how to assist permit specialist kind of notion. We have sidelined it in most of our meeting discussions, but we would like to focus on what role would be beneficial. We've talked about this in terms of across different permitting programs conceptually, but we would really like to hear from folks as to what would be useful any concerns that they have. So that's our next one. And then we also have a date reserved on the 30th. And I would like to send out an agenda on that meeting because we would like to also make sure that we have all of the improvements and suggestions if staying with the court process to be able to advise the legislature on staying with the court, what could be done in that venue. So the 29th and 30th are the next opportunities to share information, but please, as always, feel free to email me and I will be updating the correspondence that we got so that everyone is sure to have seen all of the different comments that we've gotten written.
And I think what Brooke means is she will update our Act 181 progress page on our website, right, Brooke?
Yeah, and I have I have the summary document that I've been updating every couple of weeks, just to keep everybody informed. It's all of that information is on the appeals website, but it does keep it in a comprehensive whole for reference purposes.
And I'll just give a plug for all of the other ongoing work that we're doing. You can find it all on the website under the Act 181 menu, pull down menu. So thank you very much for coming, everyone.
We need a motion to adjourn, please.
Oh, yes, we do.
So
It is a board
moved.
meeting this time. Thank you,
I'll
Alex.
second.
Thanks, Sarah. All those in favor, please say aye. Aye.
Aye.
Aye.
That is 5. That is unanimous. The board is adjourned. Thank you.
Exactly on time.
Thank you for your time, folks.
Yeah, you're welcome. Well,